Good afternoon, everybody, and welcome to our In the Boardroom with Attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. We are now, can't believe at the end of fall, school starting already. Today is our August In the Boardroom webinar on county regulation of short-term rentals. I'm Sarah Diedrich Kastorf, the Director of Outreach and Member Engagement. I won't be facilitating this discussion. I will be doing introductions. Since Rebecca is on her own today, I will assist her with the Q&A sessions as well. And then at the end, I'll pop back in and talk to you a little bit about what we plan to do in September and October. So again, our webinar today is on county regulation of short-term rentals. If you have any questions during the webinar, please enter them in either the chat or the Q&A, and I will assist Rebecca in monitoring those throughout the webinar. If there is a question that is urgent and that I think or Rebecca thinks we should be answering as soon as it pops up because it relates to the topic she is currently discussing, I'll interrupt and we'll talk about that. Um, at the uh, at the end of the webinar, if we did not get to all of your questions, we will stay online until we get through all of the questions that you have for us today. This webinar is being recorded, and so the recording, along with the PowerPoint presentation, will be placed on the WCA website. I would say, based on other schedules, by the close of business tomorrow. So again, no, typically we would have this up by the end of the day today. I think our web person might be out of the office until tomorrow. So again, it will be up hopefully by the close of business tomorrow. Um, with that, I don't think I have anything else to add at this point in time. I see there is something in the chat and Q&A. I'll respond to that online. And I'm going to turn it over right now to our friend, attorney Rebecca Roker from Attolles Law, to talk to us about our county regulation of short-term rentals.
Thank you, Sarah. Hello, everyone. It's great to be here. I was supposed to be joined by both Andy and Malia Malone today, and both were called out of the office on urgent county matters. So that's what we do here. So you get me solo today. But I'm very excited to be here because short-term rentals is a land use topic that is fascinating to me from a legal standpoint because we have so many different layers of regulation. And because they're really a new phenomenon, if you will. So we have a lot of emerging legal issues that are really, really brand new, and we don't see that in the law very much. So with that, let's get started. All right, so this is a brief overview of what we're going to talk about today. We'll do a statutory overview. Like usual, I'll kind of go through that pretty quickly because I want to make sure that we have enough time to really talk about the meat of what I'm sure many of you are wondering is, well, what the heck can the counties regulate? And then we'll talk about where we're going. As I mentioned, this is a new area of the law, and so we'll talk about some legislative changes and some very recent case law. All right, just one brief note on terminology. Most of us use the term short-term rental for Airbnb, VRBO. You're going away with your family, you find a house on the lake, you rent it for 7 days, short-term rental. Interestingly, that term is defined in the statutes as a residential dwelling that is offered for rent for a fee and for fewer than 30 consecutive days. That makes sense, right? Interestingly, though, in the statute and the administrative code, where we find the meat of short-term rental regulation, it uses the term tourist rooming house. And so if you hear me say tourist rooming house or in references to the statute or the admin code, it's a reference to tourist rooming house. Know that for all intents and purposes, is a short-term rental. Just wanted to point that out because tourist rooming house, at least for me, is not in the typical lexicon, if you will. Okay, so Many of you are most likely familiar with the right to rent law, and that's really the starting point for our discussion of short-term rental regulation. The right to rent law really was a statutory response as a result of the boom in short-term rentals. Thank you, Airbnb and VRBO. And like with many things that are, explosive in the marketplace, they have great benefits, but then they also can create some challenges for local regulation. And so what we saw were local municipalities, what I think some would say overregulate, and the legislative response was the right to rent law. And so, again, from a statutory standpoint, this is our starting mark. But a full discussion of short-term rentals really goes beyond the right to rent law. And I think that's actually perhaps the first mistake that we see occur is when folks only focus on 66.1014 and that right to rent law. Yes, it's important. We'll talk about it. But with short-term rentals, there's a whole other body of law that we have to apply to make sure that all of your ordinances are enforceable. All right, so back to right to rent law. This does apply to counties. We are included in the definition of local municipality. Um, it applies to any ordinance. So if you are regulating short-term rentals under a zoning ordinance or another licensing scheme, right to rent laws apply across the board. And now we have another definition of residential dwelling, any building structure or part of a building or structure that is used or intended to be used as a home, residence, or sleeping place by one person or two or more persons maintaining a common household to the exclusion of all others. So that seems pretty straightforward, but like other statutes, when we have all these words, all the words become important. And you'll notice as we go through our discussion, why certain terminology in this definition of residential dwelling can sometimes create issues. So, what's the gist of the right to rent law? For purposes of our discussion today, and what counties may regulate, we really hone in on the time limitations that 66.1014 apply. So, a county may not prohibit short-term rentals for a period of less than 7 consecutive days. Um, a county may not prohibit the rental of a residential dwelling for 7 consecutive days or longer. So right there, we've got a prohibition on less than 7 and prohibitions relating to 7 or longer. So what can we do here? A county may limit short-term rentals between 7 and 29 consecutive days in a period. However, you can only have that limitation, or you can have that limitation up to 180 consecutive days within a 365-day period. So, translation, a county may limit the number of rental days, but there's limitations on that limitation. And so because you've got these steps in that time limitation, of course, you want to make sure that your ordinances are carefully drafted. The ordinances that I see most frequently will lift the language directly from 66.1014 to make sure there's no ambiguities created or no loopholes that someone may be able to exploit in an ordinance. Keep in mind that your short-term rental ordinance doesn't have to have time period limitations. You don't have to have that 180 consecutive period within the 300 or 180 period within the 365-day window. You don't have to have any time limits at all. So keep that in mind.
Rebecca, can I stop you here because there's a question on the 7 days?
Sure.
It says, can you discuss the 7 consecutive days? There's a lot of interpretation about blocking and allowing shorter rentals during the period. And then there's also another question about should the first bullet read may or may not?
Okay, you're gonna have to help me out, Sarah.
Okay.
How do I go back? I'm just clicking going
Oh,
forward.
do you have the arrows on your computer?
Nope.
Okay.
This is,
Um,
oh wait, hold on. Let me try these arrows. There we
there we
go.
go. All
There
right.
we,
Yes,
okay.
third
All
bullet
right. So
point says
first
county
one,
may prohibit short-term rentals.
yeah, let me, you know what I'm going to do? I'm going to go right to the statute because, um, this is a point where when we're talking about these time layers, obviously the word not becomes very important. And so 2A, subject to sub D says a political subdivision may not enact or enforce an ordinance that prohibits the rental of a residential dwelling for 7 consecutive days or longer. So that is actually our second bullet point. Um, the next bullet point, if a political subdivision county has in effect another ordinance as of 9/23/17 that is inconsistent with this provision, it may not be enforced. Then we get down to the longer period of time when we're talking about the 30 consecutive, or I'm sorry, the 180 consecutive days. Um, and so when we are looking at the first point, I think that, yeah, this is obviously an important point. I think that is correct, though. Um, we cannot enforce an ordinance that prohibits the rental of a residential dwelling for 7 consecutive days or longer. So our starting point being the 7 consecutive days or longer. So less than 7 consecutive days, we can regulate. And I know that some counties do that. Um, so hopefully that answers the question. And then Sarah, what was the other
Yeah,
question?
the first question was about the 7 consecutive days, indicating that there's a lot of interpretation about blocking and allowing shorter rentals during that time period.
Um, I guess I don't understand the question. So are counties allowed to regulate blocks
Yeah.
or,
And maybe the individual who asked the question, if they want to type into the chat some additional information and some additional clarification on the question, we can come back to it.
yeah, that would be great. All right. Okay. We're now still under the right to rent law. A very important provision of Chapter 66.1014 is the licensing requirements. So anyone who is renting or maintaining, managing, or operating a short-term rental for more than 10 nights per year must have a license from DATCAP. And that is set forth not only in 66.1014, but then we also have cross references in Chapter 97 of the statutes and the Wisconsin Administrative Code. One thing I wanted to mention here is that the Wisconsin Administrative Code also allows counties to be local agents for DATCAP. And I know many of our counties on in the boardroom today are local agents. And so what we've seen counties do is piggyback off of their work as a local agent and sort of overlay that work in the development and adoption of county regulations for short-term rentals. So essentially, when a county is acting as a local agent, they also then act as the county agent, and there's this sort of piggyback of efforts. And we'll talk about that in a little bit more detail in a moment. So 66 does allow uh, a county to require a license if one is maintaining, managing, or operating a short-term rental. If there is an ordinance requiring such a person to obtain a license. Okay, great. Here's our statutory authority that allows counties to adopt an ordinance requiring a license to operate a short-term rental. From a legal standpoint, this raises a question because is a license the same thing as a special use or a conditional use permit? The short answer is yes, the courts have not said that it must be a license, that a county may regulate by a special use or a conditional use. But I just wanted to raise that point. So this can impact how you may want to draft your ordinances, or from an enforcement standpoint, it may have some impacts as well. But so far, we have not had any legal challenges to any sort of special use or conditional use zoning requirements for short-term rentals based on the language in Chapter 66. Okay, now we kind of shift to Chapter 97 of the statutes, which is it's the chapter that sets forth DATCAP's broad regulatory authority, and not only short-term rentals, but it also addresses food regulations, vending regulations, hotels, motels, beds and breakfasts, etc. So it's a very broad statute, but again, we're honing in on obviously the short-term rental component. And so Chapter 97 tells us that, again, that no person may conduct, maintain, manage, or operate a tourist rooming house. Again, there's that difference in term, short-term rental, if the person has not been issued a license by DATCAP or the local health department that has agent status. And again, that's a county acting as an agent for DATCAP, and then the issuance of that DATCAP license comes directly from the county. Interestingly, under Chapter 97, a county may require a separate license for each short-term rental. This is a significant point in very tourist-heavy counties where entities or individuals may have many short-term rentals. And then the question is, do they just need one license for each one, or one license for everyone? And the statute tells us that, yeah, we can require separate licenses for each. We don't have to require separate licenses. I'm sorry, separate licenses from the DATCAP standpoint are required for each one. However, there are mechanisms to have a more fluid application process if there are multiple short-term rentals under one ownership that allow a more effectual approval and review process. Importantly, you can condition issuance of a license for or upon correction of other lodging violations again. So when we have scenarios, I'll use the term a slum landlord, slum short-term rental landlord, who has violations in other short-term rentals, that may be used as a basis to condition issuance of a new license or the renewal of a license. And we'll talk about termination as well. So it's helpful from an enforcement standpoint for counties. License durations, state says that they expire June 30th of every year. So we're all on a uniform calendar. However, if a license is issued between April 1st and June 30th, the expiration is June 30th of the following year. So DATCAP gives a little bit of extra room if you apply during that April to June period.
Rebecca, can I stop you here for a question?
Yeah, yep.
All right, the question is, can a county impose a license if municipalities in their county also have a license requirement?
That is a great question. And I think that if it is if it's under the scheme of a zoning license or a zoning mechanism, the county can, and then it would apply to the unincorporated areas that are subject to county zoning. That's the most frequent um, regulatory scheme that I've seen. Um, if there's a question of may a county adopt a license requirement that's not a zoning ordinance, that applies everywhere, I think it may under its police power authority, but I think you have to be very careful. And one of the cases we're going to talk about is a case out of Waukesha County, where the court specifically addressed what is a zoning ordinance and what isn't a zoning ordinance. And in that instance, a village adopted a non-zoning ordinance short-term rental ordinance. But the court found that it was a zoning ordinance. So how does that apply back to counties? If a county were to adopt a county-wide licensing non-zoning ordinance, but you've got other municipalities who are already regulating short-term rentals, the county's gonna have to make very sure that its ordinance stays within the statutory authority for counties, and it doesn't look like a zoning ordinance, and you're making it apply to those areas that wouldn't otherwise be subject to county zoning. So the long answer is maybe, but be very careful. All right, back to our DAC licensing requirements. We always have to do a pre-license inspection. Transferability of those licenses is restricted. Immediate family members may transfer, or a business entity. If you're a sole proprietorship, the mom and pop who want to transfer it into an LLC, if mom and pop are the if they're the members or they have the ownership interest in that LLC, you can transfer the license. Or if it's a entity to entity transfer, if you've got the same ownership interest in that newly formed entity, it may transfer. All right, now we're moving on to the Wisconsin Administrative Code. ATCP 72 is where we find the real meat of the regulations for short-term rentals. Again, we've got this different definition of tourist rooming house, but for our purposes today, tourist rooming house and short-term rental we're going to use those terms interchangeably. And there's no case law that, again, for purposes of our discussion, makes a distinction that is significant enough where we have to make that distinction today. So again, I'm going to be using those terms interchangeably. All right. Again, ATCP 72 is where we really see the comprehensive regulation of short-term rentals. ATCP 72 sets forth all of the application requirements for that state license. It is a person may apply for their initial license, and then if they want to renew every year, there's a separate renewal process that's a bit shorter. Once a application is submitted to DACAP, or the local agent, if the county's acting as DACAP's agent, it has to be reviewed within 30 days, or a response that the application is not complete within that 30-day time frame. There are specific statutory basis upon which, when I say statutory, ATCP is obviously an admin code, but it's based on the statutory authority granted to DACAP. And I set forth these in detail here, and I won't read them all, but I think it's important to see how the legislature has clearly defined the basis upon which either, again, DACAP itself or that local agent can deny or refuse to issue an initial license or a renewal. And so when you're looking at drafting even county ordinances, this is a very good place to copy and paste, if you will, for your own county ordinances in terms of the framework for review and denial. And so these are quite comprehensive. And the last being really a catch-all when you look at that very broad language. Any violation of Chapter 97, ATCP 72, or any other order, ordinance, or regulation created by all of these different entities. If the violation is, of hotel, motel, or short-term rental. Obviously, that's very, very broad. And so again, I look at that as sort of a catch-all. If you ever were going to use that type of catch-all, talk to your corporation counsel, because obviously we want to make sure that we've got the required facts to be able to sustain a violation if one, or a termination if one is issued. All right, what are some of the other items in ATCP 72 with respect to denial of an application or non-renewal? The DACAP or local agent acting for DACAP must provide that notice in writing. It must provide details for the reasons of the denial. Again, all of those reasons that were on the last slide. And then you have to set forth the appeal rights that are in 97.625 and 7208. And that is a review process pursuant to Chapter 227, which goes through the Wisconsin Division of Hearings and Appeals. And there's a new statutory requirement, or relatively new, that you also have to give notice to the DACAP secretary. So appeals go through the Division of Hearing and Appeals. What are some of the other items that are regulated by ATCP 72 that deal with short-term rentals? Water supply and waste disposal. Obviously very important for public health, welfare, and safety. So we look at 7210 for regulations regarding utility services versus private systems. What types and the threshold of water supply. Then we get into things such as how much soap, how many towels, where does the drinking water have to be accessible, garbage containers, things that are really relate to cleanliness. So when we're thinking about water and waste disposal, how to keep these facilities clean and healthy. Plumbing is referenced in ATCP 72, but then we also have to look to the DISPUS admin code, which is SPS 382. So there's some references today that you'll hear between ATCP 72 and then SPS 382 as it relates to plumbing and sizing, because that becomes or may become an issue when we're talking about occupancy. So we'll get to that. Then under ATCP 7211, we get to things like furnishing or furnishings. They have to be easily cleanable, sanitation requirements, cleanliness of linens and towels. They have to be new once a week. I'm going to be honest with you. When I read this, I thought, oh my gosh, these are the minimums. I'm so appreciative of all the facilities out there who go above and beyond these minimal requirements, because these really are minimal. Employee health, a person who has a communicable disease shall refrain from working in. So obviously not a blanket prohibition. However, in the next section, it states that an operator may not employ a person suspected of having a communicable disease. So those two, don't necessarily jive completely. And so that creates an opportunity for ambiguity. And then you've got the whole other challenge of how is the county going to enforce a situation like that when we're dealing with an operator's employees. And then ATCP 7214 looks at the building structure and the safety. And again, we have to look to other administrative codes, specifically SPS 361 to 365, which give us the state building codes. And then interestingly, DACAP becomes the enforcement body for SPS 361 to 365 relating to fire detection and fire safety requirements. So in this instance, SPS 361 to 365 set forth specific fire detection and fire safety requirements, but DACAP becomes the enforcement body with respect to licensing of short-term rentals. That then also applies to the local agent. So if you are a local agent, you are acting on DACAP's behalf, but then you are also acting pursuant to the SPS requirements. So again, those multiple layers of regulation can become very complex. ATCP 7215 requires carbon monoxide detectors, again, for health and safety, overall maintenance. It's nice to have that catch-all that TRH is a shortened version for tourist rooming house, short-term rental. Each has to be maintained and equipped in a manner conducive to health, comfort, and safety of guests. That sure looks like the police power standard, health, welfare, and safety, which when we talk about the bases for county regulation, and if we're basing the authority on public health and welfare, this is good language to look to as support for the county's authority to regulate. Again, just a couple other interesting items that, the standards for clean and sanitary conditions, they have to be in a good state of repair. We have to have effective measures for insect and rodent control. Again, thank you, short-term rentals out there who handle that I've stayed at. And then overall, the premises have to be maintained in a clean, neat condition, free of refuse and other objectionable conditions and hazards. A very broad catch-all that one could look to if trying to enforce a more unique or unanticipated violation. Okay, proof, right? And it's only 12:31. So yay, we're going to have more time to talk about specifics. And in this instance, it is important to talk about all of those provisions of ATCP 72 because we're going to see that they're being proposed to change. And so it will not be a complete waste of 32 minutes. But let's talk about what can a county regulate? This can become a philosophical discussion, and I've actually had some of these discussions with our friends at WRA. From the county's standpoint, our regulatory goal is to minimize or eliminate the impacts that result from short-term rentals. What do we see as the most common ones coming from counties? Noise, bachelor parties, big family reunions, big, noisy, loud music, tons of people. Tons of people can mean tons of cars. Where are all these cars going to park? Are there going to be, a side lawn adjacent to another property owner that it just becomes a parking lot? Garbage, lots of people. There's going to be lots of waste produced. And so, do you have one garbage can? Is it thrown on the lawn? What do you do? Impacts on natural resources. Think of how many short-term rentals are on our Wisconsin lakes. Obviously, that is a very attractive place to spend a family vacation. And so does this continual influx of visitors, short-term renters, have an impact on natural resources? And if so, what can counties do about it? Very frequent impact that I've heard in working with counties is this changes the character of the neighborhood. We are doing a commercial use in a residential setting. We don't want that, and it goes against the principles of zoning. And so how do we then minimize these impacts? In these philosophical discussions, many like to argue that we use our existing ordinances and state laws. If somebody's being too loud at their bachelor party, there's noise regulations perhaps in an ordinance. Enforce those. If someone is, and I'm sure many of you have interesting stories of things that you've heard being or are happening at short-term rentals that we could, talk about over a beer at the conference, and all of these crazy stories of what people have seen happening at short-term rentals. They might rise to the level of disturbing the peace. We've got ordinances for those, right? Let's just enforce those. And then if it gets really out of hand, we can issue disorderly conduct citations. But what do all three of these have in common? They all require law enforcement. And for counties who are already strapped for law enforcement resources, my perspective, and Andy and Malia would agree, that why don't we look to a different mechanism of regulation where we're not straining law enforcement and not relying on traditional disorderly conduct or criminal laws to deter and minimize the effect of these short-term rentals. So that's point number one. And the other one, or the other basis I think that is really important to remember for county regulation of short-term rentals, is if these folks are here for a week, unfortunately, they may not care about the property. So law enforcement issues them a ticket. We're leaving on Sunday. I don't care if I have a Vilas County ticket. Go pound sand. Unfortunately, there are folks out there like that. So again, typical law enforcement just may not be the best option in order to minimize the impacts on short-term rentals on neighbors. Okay, so how can a county regulate? And there's generally two different ways. You can either regulate through a zoning ordinance, and that can be either like a special use permit or some sort of administrative permit that only goes through administrative review and doesn't go through your zoning committee. Or you may have a conditional use permit or a special use permit that is issued with specific conditions and does go through your zoning committee or your ordinance process. I would say from my experience, the vast majority of Wisconsin counties regulate by zoning ordinance. There's a mix of some administrative review, some conditional use, issuance of a conditional use permit. Obviously, a conditional use permit, you can dig down deeper into specific conditions, but with that, comes some legal requirements, which we'll talk about. The other option is a licensing ordinance. And this is where I was talking about the piggybacking off of your work as a DAT-CAP agent. So when a county is acting as a local agent, they have their checklist, they have to go in and inspect as if they were working for DAT-CAP. Well, some counties take the perspective of, we're already there doing that work. Why don't we require a county license that works in lockstep with the state license? And so that can be a very effective tool for counties that have a huge number of short-term rentals. We have some counties that have hundreds of short-term rentals, and that means a zoning committee would have to review hundreds of short-term rental applications. And that is just not feasible. So how can a licensing ordinance be as thorough as a zoning ordinance without having to go through the process that a traditional conditional use permit does? The answer is yes, but we have a case, and this is the case I was referencing out of Waukesha County. The Village of Summit adopted an ordinance that it claimed it was a licensing ordinance, not a zoning ordinance, because it applied countywide. So the village did not go through the due process steps of having a public hearing and checking all the boxes that they're supposed to when adopting a zoning ordinance. The person who received a violation said, no, this ordinance is a zoning ordinance, like looks like a duck, walks like a duck, that argument. And so what does the court do in that situation? We look to this Wiefelhofer case, which is a great case because it tells us straight out there is no bright line between a licensing ordinance and a zoning ordinance. There is a whole host of factors that a court will look to when deciding whether a regulation is indeed a zoning ordinance or it's a typical licensing ordinance. And the importance of that difference is because of the protections that come with a zoning ordinance. And there are more due process requirements if this is a zoning ordinance. And so here the court said, no, this walks like a zoning ordinance. It looks like a zoning ordinance. It's a zoning ordinance. And so right now, this is at Court of Appeals. The decision was issued, I believe, July 9th. So we don't know if the Supremes are going to take it. But it's a fascinating issue because it goes directly to this option of, do you want to regulate under zoning or do you want to regulate under licensing? And this is a reminder from our courts that say, yeah, you can do it under licensing, but you got to be really careful. And so what is our key point there? Your ordinances should be well-reasoned, thorough, and legally compliant. Work closely with your corporation counsel. Reach out to WCA with questions. But this Wildwood Estate case is, I think we're going to see more of this analysis when looking at county ordinances that are deemed licensing ordinances, but are really, for all intents and purposes, acting like a zoning ordinance. All right, so now we're back to what can a county regulate? Because we talked about the how, so now we're back to the what. The short answer is anything not inconsistent with state law. So that language specifically appears in 66.10142C, which again is our right to rent law, not Chapter 97 that deals with short-term rentals. So again, we're back to the right to rent layer, which tells us that counties can enact an ordinance regulating short-term rentals that is not inconsistent with the limitations on municipal regulation. And this right here, folks, this is our statutory authority that we need as counties in order to regulate. Obviously, counties are different than cities, villages, and towns. We have to have statutory authority to do something. This is ours when it comes to regulating short-term rentals. So we can regulate anything that's not inconsistent with state law. When we're applying that legal theory, it's always helpful to look at the requirements of preemption. And these 4 bullet points that you have under preemption are very, very helpful to, from my perspective, when we're looking at a draft ordinance or a regulation, to walk through these points and say, you know what, how are we getting around what the state statutory intent is? Are we being too creative? Are we going outside of our statutory authority? I had one county say to me once, are we getting too cutesy? Like, that is a perfect definition of acting under a preemption analysis. Like, are you getting too cutesy? Are you getting outside of your lane here? So I wanted to include these just as helpful points when you're thinking about a county regulation and whether it is not consistent with state law. And again, we go back to the analysis under the right to rent law. We have to look at those timeframes. But then, and again, all of those requirements under the right to rent law. But then we have to take another step. And again, this is another layer in the analysis. When we're talking about zoning ordinances or even licensing ordinances that look like zoning ordinances, what are those due process considerations? What is the proper application of those underlying legal standards for your regulatory mechanism? So if you're using a conditional use permit, are you complying with the requirements of 5969 5E for substantial evidence required for conditions? So again, we got to comply with the right to rent law, but then we also have to comply with those underlying legal standards for the regulatory mechanism that is being used. Okay, so let's talk about some what I call low-hanging fruit regulations. What are some things that counties can clearly regulate? Um, if an ordinance was dropped on my Andy or Malia's desk, and we saw these items, we would have no concerns. Of course, assuming there's nothing wacky thrown in there. But so what are some easy ones for a county? The duration. We know from the right to rent law, the 66 1014, you can prohibit short-term rentals less than 7 days. That goes back to our earlier discussion of what the language of 66.1014 is. And then we know that you can prohibit for more than 180 days in that consecutive 365-day period. So we know those for sure. Um, then we get to items like garbage receptacles. You can have requirements for garbage receptacles removals. You can have requirements that you see in ATCP 72, smoke detectors, fire extinguishers, other fire safety requirements. Um, no loose dogs or animals running. That's a frequent complaint that I think counties here is you've got, visiting dogs and they're running all over everybody's lawn. You can have something in your short-term rental ordinance regulating those animals that are unattended. House rules. I think a county clearly has statutory authority to require that those rules be posted inside for the renters to see. Having an owner or agent contact for renters and neighbors. I think that's a clearly defined requirement. We'll get into some concerns with that requirement but from a general standpoint, yes, a county can require that there be an owner or agent contact provided to the renters or neighbors. Clearly, you can require that your applicant complies with tax reporting laws and other applicable laws. And then this last one is, again, we get back into, what mechanism are we using to regulate? Even if we're not using a zoning ordinance, if we have a licensing ordinance, I think it's still appropriate that you require a site plan, a floor plan, a parking plan, or other information relating to use as part of that licensing ordinance. Because again, there's this rational relationship, right, between what you are trying to regulate, minimize risks, and then these are all consistent with state law. So again, these are easy ones. These are low-hanging fruit for a county. What are some that they're probably fine, but may raise some issues? Property insurance in reasonable amounts. We had a situation where the insurance threshold was like $10 million. Depending on the premises, that might be appropriate, but for a 500 square foot cabin on a lake, that might be excessive. So just make sure that that what your requirements are reasonable and not trying to have a deterrent effect. Proof of registration and compliance with sales tax and other tax requirements. This is different than saying you have to comply with all the sales and other tax requirements. Now here you're requiring proof of registration and compliance. That's probably fine, but depending on what type of documentation you're requiring, it may get a little sticky. Parking regulations, to the extent that they are fair and reasonable and are not excessive as applied to short-term rentals. So for an example, excuse me, an ordinance saying no on-street parking in front of a short-term rental. But then the neighbor who is, owner occupied can park on the street. That's where we get into a difference in that regulatory scheme. So avoid no on-street parking that is specifically directed at the short-term rentals. But requiring a parking plan that absolutely is reasonable as part of that application process. The next one, proof of homeowner association or condominium association approval. This is an interesting one because whoever came up with this idea as a point of regulation, I think it's a very good one. Hey, you're in a condominium and you want to rent out, your rental. What are your neighbors going to say if you are already bound by this condominium association or homeowners association? Well, let's make sure that you have approval to do that. And so I think it's appropriate for a county to ask, is there a homeowners association or condominium association restriction? And if yes, then I think the county has authority to say, well, then you need to show us that approval. Um, Next one, the owner agent representative, that point of contact, as I said before, that is appropriate to require. However, it has to be within a reasonable distance. And this totally depends on the context of your county. Some of our northern counties, the point of contact may be, 30 miles away just because of the landscape of that county. If we're talking about another county where it's more concentrated, 35 miles away may be excessive. So you certainly can have that owner agent contact required, but if there's a distance requirement with it, just make sure it's reasonable. The next one, maintaining records of occupants. The law tells us that you can require a log of who stayed. The question becomes, what else? Are you asking for amount paid? Are you asking for payment records? Are you asking for more information than the law allows? So if you're going to have record requirements, be careful with those. Quiet hours are most likely fine, as long as they're reasonable. We often see 10 p.m. to 7 a.m. Highly recommend that your ordinance detail what quiet hours are. No excessive noise, have some standards, but that at least will give adjacent landowners some comfort that the county is looking at that excessive noise as an offshoot of a short-term rental next door. And then no advertising on the rental property. So you've got a short-term rental, you may prohibit a sign that says for rent, Windy Farms Estate. I just made that up. I'm not aware of one named that. That can be prohibited. And again, all within reason. All within reason. All right. What are some that are questionable? These are the ones that when they're raised to me and Andy and Malia, we go, maybe. The most frequent is prohibiting a short-term rental in a residential district. This goes back to case law from 2015 that says a municipality, including a county, cannot prohibit short-term rentals in a residential district because there's nothing inherently, there's no time element that is inherent within the concept of a residence or a dwelling. And so here, the city of Cedarburg could not add that time element and create a prohibition within its residential district. And so that's why we always recommend that you look to the use. If it is a residential use, be very careful how you are regulating a short-term rental, again, regulation based on duration, in that residential district. Many of you are probably saying, well, where the heck else are we going to have short-term rentals? They're all in neighborhoods, or most are in neighborhoods. That's where we have to have some creative ordinance drafting. One of them that I find very interesting comes from Vilas County, which is it's an older case, and it lots of different issues there, but a good takeaway is that there is a resident lodging district. And so there was a specific zoning district created for acknowledging a residential use that had a, um, this element of tourist or rental properties or other short-term lodging uses in it, which is a good option. The For She case, this is one of my favorite cases of all time, not only because it happened in one of my favorite counties, um, but fascinating case. There was a deed restriction on a parcel that said the property could not be used for commercial use. There's a short-term rental, and our court said, no, that's a residential use. It's not commercial. They're living in the property. Holy cats. There, lots of people said that that did not make sense. Um, so be very careful if you have ordinances that have a commercial use element and prohibiting an action or a type of use in a residential district. Again, Forshee's facts are unique, but I could see how a court may take that analysis of the commercial use in a residential district and then overlay it, on a broader short-term rental analysis. Okay, other questionable regulations. If you have a blanket requirement with all commercial building code requirements, be very careful in how you are establishing those building code requirements, again, to make sure that we stay consistent with state law. Owner occupancy requirements. This is something that it was the city of Milwaukee was attempting to do. To me, it's just totally counterintuitive for the vast majority of short-term rentals. The owner is not going to be staying at the house if the house is being rented to another family for a week. So that one raises lots of questions. Specific signage designating a property as a short-term rental. The goal being, let's let folks know that this is a short-term rental. If you're requiring a sign outside of that saying short-term rental, that raises some legal concerns. So again, if that's something that your policymakers are interested in, talk to your corporation counsel. And then again, requirements for that owner or agent. If the owner or agent has to be, within 30 seconds of the premises. And it says excessive mileage restrictions, and that it's actually, I meant that to be the inverse, if you will. And then posting contact information on the exterior of the property. That goes back to that signage and the designation of a short-term rental on the outside of the property that's visible from the street. All right.
If I may, just a reminder, it is 12:58.
Yes.
So you have
Okay.
quite a few slides left.
We
And,
do.
and we have a number of questions. I don't know what your
Okay.
time restriction is today, Rebecca, but we can keep going if you have time to
Well,
get
what I'd like
to,
to do, what I would propose, Sarah, this is also a presentation at the annual conference in September. And so on Monday's meeting, Andy said, let's give a little teaser for in the boardroom. And this is kind of a teaser for the presentation at the annual conference. So I'm okay. I think this is a good place to stop, if you will. And with the understanding that I'll just summarize and say we do have new case law coming down, as we talked about with the Wildwood Estates. DATCAP is looking at revising ATCP 72 right now, so we may have some change in regulations. But then we can do that deeper dive, at the conference too. So I think maybe now's a good time to stop, and then we can do questions. What do you
okay,
think?
let's get through because we have quite a few questions. So we'll go through
Okay,
those. And again, for the slides that you did not get through, they will be posted on the WCA website as well. So they
great,
will be made available to everyone. And the same with the conference slides. Those slides will be posted to the WCA website as well. So
awesome.
back to the questions. So David got back to us with regard to the 7 days, where he indicates that some counties allow a 3 or 4 day rental within 7 days, with the other days being vacant. And some counties require the term of the rental to be 7 days. So is there anything in the statute to favor or require one of those two interpretations?
Short answer is no. And Malia and I just had this discussion yesterday. My perspective being, help me understand if we can, if there's that 7 days, the benchmark, how are we regulating 4 days? Like how does that all work together? And the short answer is you can be less restrictive than what the state statute requires. But there is no specific provision in 661014 or anywhere else in the statute that clearly sets forth number of days, break-in days, things of that nature. Um, the only time blocking, if you will, is that requirement that with respect to the 180 days in that 365-day period.
Okay, and we may have gone through this next question already as you were going through your slides, but there was a question, what type of restrictions or conditions can zoning impose on a short-term rental? Is it completely open?
No, it's not completely open. And this is where we get back to the requirements of 5969 5E, and that the conditions have to be supported by substantial evidence. They have to be reasonable. They have to be measurable, if possible. They can't be based on opinions, emotions, etc. And so all of those that legal framework of conditional use permits still applies in the regulation of short-term rentals. So what are reasonable conditions? I think that's where we look back to, low-hanging fruit options. Those would be deemed reasonable conditions if the county can articulate why those are important. And I think we can easily articulate why each of those are important, from a very basic level. If you've got a conditional use permit and one of the conditions is your agent contact has to be available in 10 minutes or less to be on site, why? Now we get into a more restrictive condition. We have to have substantial evidence to support that condition. So again, the analysis of that legal analysis that applies to conditional use permits also applies to the issuance of a conditional use permit for a short-term rental.
Okay, let's see. Does VRBO and or Airbnb have any clue about the DAT license needed? It seems Airbnb just show up on the website without any knowledge from local zoning departments, and we are tasked with hunting them down. That may be a
Alex,
comment or frustration more than an actual question.
yeah, I don't know. And when I was at DACAP, that was it wasn't that long ago, but that was definitely before the boom of Airbnb and VRBO, which I gotta say I'm kind of glad about because what a nightmare to be a state regulatory agency and have to tackle this massive market, um, this massive platform. So I don't know the extent to which there's communications between DATCAP and these platforms. I would think that DATCAP does its very best to have facilitation of communications. There are some requirements, and I didn't include these, but if you may have a requirement that if you are using one of those platforms, that there be certain registration thresholds. But that's more on the applicant side of ensuring compliance rather than, a dialogue with the platforms themselves of making sure people comply with local regulations.
Okay, and we have several questions, at least 9 or 10 questions
Oh
left.
my,
So yes.
I
So
hope you're all coming to the conference.
yeah. All right, it says ACAP 72 definition issues. They define sleeping room, which is challenging with regard to POUTS regulation, where
Mhm.
bedroom is defined as having 2 people per bedroom. Are counties the only entity that can enforce POUTS, or can they allow the municipality? Pout's number of people is used to ensure proper capacity limits.
That is one of the items on a later slide that that the sizing and Pout's requirement can be a very useful mechanism to regulate occupancy. And I think that there is a rational basis in that. If you've got a system that can only support, let's say, 10 occupants, well, heck, you shouldn't be having an occupancy limit of 20, right? That makes sense. However, as the person who posted the question noted, there's no clear definitions within ATCP 72. And then when we look at the definitions in the SPS, it's sometimes really hard to reconcile those. Unfortunately, the revisions that DACAP is proposing to ATCP 72 do give us more guidance on occupancy. However, it doesn't address the POUTS elements or the sizing requirements. Another part of that question was I think whether it's the county's sole obligation to enforce POUTS regulations. Was that part of the question, or am I remembering incorrectly?
Yes, no, it says, are counties the only entity that can enforce Pouts, or can they allow the municipality?
I don't know for sure. I I don't know. I mean, I can certainly check and I can certainly find out. I'm trying to remember if there's something within chapter 23 or the other conservation statutes or the other DISPUS statutes that specifically assigns those responsibilities to counties, and I don't know. Um, and that's one of the, we don't, we work with some cities, villages, and towns, but not nearly as much as with counties. So I'm just not sure whether those obligations are also extended to municipalities. But
Okay.
that's a great question.
Okay, yeah, I was going to say, I think this next question is very similar about private septic systems having different occupancy numbers and asking for suggestions on how to coordinate the issuance of the ACAP permit with occupancy based on the septic sizing.
Mhm.
So I think that you covered. How do hip camps come into play?
What's a hip? What?
I don't, okay, I will admit here, a hip camp, I Googled
Oh,
it, a hip
oh,
camp.
like an outdoor camper?
Like
Like,
it's like an Airbnb, but for I think campgrounds. Like what a
oh,
hip camp is.
okay. That's
For
interesting.
people renting their land, I'm assuming, for somebody
Okay.
to put
Um,
their camper
well,
on or RV on.
okay. So what I'm envisioning, uh, again, just for example's sake, something that looks like let's say an RV park where you've got individual units on individual plots. First thing we would do is decide whether that camping unit is deemed a residential dwelling under the statutes. If it meets the definition of residential dwelling, then I think we can start the process of regulating that site as a short-term rental. Now, where we get into some challenges is what are the utilities set up as? What is the water system set up as? So those folks may not want to, you know, be classified as short-term rentals because the threshold of compliance might be higher. Um, the other option for regulation of those types of uses could be through a standard zoning ordinance relating to campgrounds and campsites. I know those can be very controversial, but many counties will have ordinances requiring zoning ordinances that require conditional use permits for that type of camping facility. Um, so that may be an option as well.
Okay, then we have a number of questions from Hugh here. It says, we have short-term rentals being used as wedding venues. How do we regulate vis-a-vis the new wedding barn laws?
Oh, that's a great question too. Um, well, I think using a premises as a wedding venue, again, we're walking that line of, is this some sort of commercial use? And that's, we have to be careful about regulating those commercial uses, in that residential zoning district. I would say the most effective way to regulate, again, I'm talking high level here, folks, um, in your ordinance, when you are addressing things such as parking, not number of occupants, but number of visitors to the premises, things that hone in on, um, those elements or impacts of having a large gathering of people, um, at a residential parcel. Focus in on those and try to incorporate those as part of your ordinance. The other option may be, um, well, I was going to say if there could be some other type of permit required in addition to, obviously you've got the short-term rental regulatory mechanism. Is there some other additional mechanism for things like, a wedding venue site or some other, um, you know, short, I don't say short-term use, but like a concert site, or a conference site, things that are like a one-time offshoot use, whether there's an opportunity to regulate that component of the use in addition to the short-term rental.
Yeah, Rebecca, new questions keep popping in. I'm wondering if
Okay.
we need to talk about a part two here.
Yes,
Finish
yes.
getting through the presentation as well as to answer questions.
Yeah,
So,
I just popped up my I think you guys can all see the questions. I'll take those off. All right, keep shooting the questions, Sarah. We'll stand for a couple more minutes.
okay. Yeah. So, let's see here. I'm gonna just, some people have asked a ton of questions. So I think what I'm gonna do is go to some other folks that haven't asked questions yet. There's a couple of questions here on enforcement. There's one that says, what can counties do to enforce its licensing requirement? And another that says, can Rebecca discuss the potential differences in enforcement capability between a zoning versus licensing ordinance?
Okay, that let's start with that question. So the most obvious is the revocation of the permission to have a short-term rental. So if you have a zoning ordinance that requires a, administrative permit or a conditional use permit, there's a violation of that, you terminate that that approval. Um, that is probably the easiest mechanism to enforce. Depending on what your ordinance says, you may be able to issue fines or other monetary citations for violations. But again, termination of that permit is the most direct and easy solution. Also, it creates the greatest impact on the owner. So often when we're talking about short-term rental regulations, and because it's this transient population who may not really care if they get a ticket because they're leaving on Sunday, you got to hone in on the ownership and make sure that the owner really understands how vital these regulations are. And if there's a possibility of termination of their ability to use this as a short-term rental, that's going to have a more substantial impact. Now, when we're talking about a license, you can also have the same scheme of termination. You can have a warning system. You can, like you get one warning, then you get one citation, then the second citation can increase. After the third citation, you can face termination. There's different possibilities of how you frame those enforcement mechanisms. The one thing I will say we've is that a court has never held that the ability to operate a short-term rental is a property right. We have law that says a conditional use permit is not a vested right, but I wouldn't be surprised if we see in the future a party make an argument that the ability to operate this short-term rental has some heightened property interest, and therefore greater due process protections are required when terminating that. And so again, what does all that mean? Just make sure that your ordinance is very clear as to that whatever enforcement mechanism you choose.
All right, I'm just going to flip through some of these questions. That's another one on septic.
Yeah, the septic, we could do maybe we should, Sarah, a
Maybe we should
whole
do a part two
a
on the
session on
septic piece.
septic
Yeah.
sizing,
Yep.
and then we might have to have some outside guests too, because when we start getting into the meat of the SPS regulations, it can get very technical. And I'm not a civil engineer, and I'm not a plumber, so I can tell you what the law says, but in terms of the specifics, at least for me, they can be challenging because we're oftentimes speaking a different language.
Yeah, because I'm looking, we keep getting additional questions. Two more just popped in.
Okay,
So
well, you do that. I'm going to keep going, Sarah. I'm going to just
okay.
jump
Okay. I
to,
didn't know if you wanted to keep going, if we wanted to
no, no,
schedule a
no,
part
no, I
two. So,
don't, I don't want to keep going, but if we've got a lot of occupancy questions, I want to jump to this slide right here, and maybe this will help answer some of these. So DATCAP is proposing a revision to ATCP 7218 to give some better clarity on occupancy requirements. So DATCAP did, like a group study. Um, I think it started in like late 2023, a working group to look at updating these really archaic provisions of ATCP 72. One of the loudest arguments was help us regulate occupancy, because right now the only thing that's in ATCP is the sleeping area and the restrictions on sizing and like square footage of how much space you need. Well, that doesn't really help us hone in on like occupancy numbers. So DACAP's attempt to answer some of those questions is the language on the screen. So it proposes that you have a spacing in between the beds, and then you have the sizing of mattresses. And so one occupant for the width of a 50-inch or less mattress, two for more than 50 inches. And then this last point is very interesting because it says that I read this as a local unit of government may establish an occupancy requirement, because this language of or the posted occupancy limit established and enforced by the local government agency, whichever is less, to me is a signal that DACAP is anticipating that local units of government are going to be regulating occupancy, and therefore it's whichever is less. Now, for a county, is that enough to give us a hard and fast green light to regulate occupancy? I'm not sure, because the how that occupancy is going to be determined comes into play, and whether it's going to be deemed reasonable. So my point being, this is DACAP's attempt at trying to clarify occupancy. It's a little something, but it is sure not what I think people were hoping for, in terms of some more definitive administrative code provisions on occupancy requirements.
Okay, so I'm just looking here. Let's see. Oh, can a county use a voluntary deed restriction as an enticement to a landowner for relaxation of a different standard? For example, can a county have an ordinance that allows a greater density within a development if the owner agrees to put a deed restriction prohibiting short-term rentals?
Maybe. Such a lawyer answer. Couple things there. And the maybe is it's got to be in your ordinance. If that is a tool that you're anticipating may be useful, you've got to put it in your ordinance. That can't just be a creative option that your county planner comes up with for this specific development. That would make me very uncomfortable. So again, get that option in your ordinance. Um, Number two, I think let's just use within the realm of a conditional use permit. So that deed restriction would be a condition of the permit to use. And so now we get back to, is there substantial evidence to support that requirement? Now, an owner is going to have to agree to that deed restriction. So the good thing about a deed restriction is it can't be recorded until the owner agrees. However, the question is if the message to the owner is the only way you are going to get this approval is if you record this deed restriction. An owner may argue, well, hey, that's not voluntary. That's, you're holding this as a threat. You're not going to issue my permit unless I restrict my property. Um, so could you? Yes. I would again make sure it's very clear in the ordinance that that could be an option. You could probably look to like a PUD ordinance and some sort of like the development agreement requirements and recording of those is maybe a baseline. For the provision in a short-term rental ordinance. Make sure the requirements are very clear. And when you have someone come in, if it's like for a pre-application meeting, make sure it's very clearly articulated to the applicant that, the county is going to require some sort of deed restriction to ensure compliance.
I know there were some comments here with regard to, licensing and the collection of sales and use tax. So they should be aware of these requirements if they're collecting sales and use taxes.
Yep,
There,
absolutely.
there's also a comment here, and maybe this goes to part two with occupancy and everything else with regards to federal ADA requirements for five or more rooms in a house. That's a whole other topic I think maybe we
That.
can discuss in a follow-up.
Mhm.
Let's see here. If the covenant preventing commercial uses doesn't apply to short-term rentals, what about covenants prohibiting subletting your property?
I think that under the 4C analysis, if it is a residential property, uh, it would not be enforceable. Again, under that analysis of 4C. But that doesn't mean it may not be enforceable under another legal theory. So as important as that case is from the general standpoint, when we start talking about commercial uses of residential areas, if we can craft our ordinance in such a way that it is narrow, I think we can accomplish that. But again, it just has to be very, very carefully crafted. The other thing, keep in mind in 4C, that was a group of neighbors who brought suit against the property owner. So the county was involved to the extent that they may have issued a permit. In fact, I'm not sure. They were not party to the litigation. Um, but that was neighbor versus neighbor trying to enforce this deed restriction. So if you have a deed restriction prohibiting subletting and it's neighbor versus neighbor, I think there's a better chance that the angry neighbor is going to be successful under 4C than the county is trying to enforce that.
Okay, let's see here. Bayfield County shared that they have a shared short-term rental position between health and zoning, who serves as the point person for both regulatory frameworks, and that seems to work well within their county.
Awesome. Yeah,
There
I
was
love that. That's a great example of piggybacking and using, county resources that are stretched thin in a very creative and useful way.
and then somebody wanted to know if there was a contact at Airbnb or VRBO to let them know your jurisdiction requires a license.
I don't know. I have never tried to find that. I would say start with DACAP because if somebody's going to crack the enormous shell of these platforms, I think that DACAP would be the best equipped to do that. Um, but there is no, what I can say, there's no legal requirement that I'm aware of that DACAP has to, or that these platforms have to acknowledge or require compliance with local regulations. I'm sure all of them would say, well, of course we require compliance with local regulations, but whether there's any enforcement to that, I'm not aware of any.
Okay, let's do one final question because I think
Okay.
the rest of them I'm seeing here will likely be addressed in part two.
Okay.
So it says, can a county regulate the number of short-term rentals similar to the number of tavern licenses that are allowed per municipality?
That's a tough one. When we're talking about tavern licenses, there is specific statutory authority for a municipality to do that. There's a permission in the statute saying you can limit. There's nothing in the statute that says you can limit the number of short-term rentals. So right there, that I think is a big checkbox in the no column. You can't do that. Um, Other things that concern me with that is almost an equal protection argument. I could see where an applicant or an owner, just because they're further to the back of the line, they can't get a permit, that there's some disparate treatment between those. I mean, that would have to be a legal argument that's flushed out. But um, as an option for regulation, that one I think needs a lot more in-depth exploration.
Okay, I just want to thank Rebecca for sticking with us for an extra half an hour
Yeah.
afternoon. I think it is clear we need to do a follow-up on this particular topic. Uh, we
Yeah.
are we are going to be taking September off because of the WCA conference, but again, the conference materials on this particular topic we will post to the website along with this recording and the PowerPoint from this webinar as well. October, we are scheduled, I think, for October 22nd, and we're scheduled to discuss intergovernmental agreements at that time. So we will certainly talk to Andy and the rest of the folks at Attolles Law to determine whether or not the topic we had originally scheduled for November will still be a go, or if we want to talk about part two for short-term rentals in November. So with that, I
On
just
that note, too, Sarah, I believe that we've got an article for the county's magazine regarding intergovernmental agreements. I believe that's on the horizon as well.
Okay, perfect. Perfect. So again, I want to thank everybody who stuck around. We had almost 200 folks join us today. So this
Awesome.
was a very large in the boardroom. And again, as a reminder, I'm hoping by the end of the day tomorrow you will be able to find this recording on the website along with the materials. So with that, thank you for joining us today, and we will see you back on October 22nd.
Thank you, Sarah. Thank you, everybody. Have a great day.